Alex here with a high conflict child custody video on M.G.T.O.W and M.R.A. These are two different movements. One's called, again, M.G.T.O.W, which stands for Men Going Their Own Way. The other one's M.R.A., which stands for Men's Rights Activists. It's my understanding that the M.R.A. group is sort of a political group that's lobbying for change and gender equality. And the other group, M.G.T.O.W, takes things a little bit further. It's my understanding that they do not believe in marriage, having children, and I think it goes further than that. I don't think they believe in even getting into relationships. Now, I'm only going to really talk about the parts of these groups that intersect with the purpose of my channel, which is the family law system. Well, I cover all kinds of types of litigation, but mainly my channel covers self-representation, and the bulk or the lion's share of my viewers are representing themselves in child custody cases and divorce cases. So that ends up sort of being the de facto main purpose. It took me a long time to come up with how I was going to really approach this video, but I think that there aren't any real hard facts and statistics available. I know that the legal system is gender neutral on paper, and that the statutes, at least in Nevada, are gender neutral. But I have to agree with both the M.R.A. and the M.G.T.O.W group, because there's too much discretion in these areas of the law. What I mean by discretion is there's too many areas where the judge has a lot of leeway, and there's a lot of distrust right now for the legal system. It's alienated a lot of people, and for good reason. I actually have a whole lot of experience in the legal system representing myself. I've even beaten attorneys and won Supreme Court rulings, or won Supreme Court cases representing myself. Yet still I come to the same conclusion as those groups do, because of the unpredictability. Because individual judges are given such a tremendous amount of latitude in child custody cases, in divorce actions, I find myself agreeing with them, because even I don't know what any random judge is going to do. I can predict pretty well what the Supreme Court is going to do, but the Supreme Court doesn't intervene in every issue. As I mentioned in my video standard of review, the only issues that the Supreme Court gives de novo review on are questions of law. And if you want to know what that means, please watch that video. I'm not going to get technical in this video. When it comes to questions of fact, and when it comes to discretion that the trial court has, the judge, the lower judge, the family judge in this context, is given an incredible amount of deference. And you cannot get, for the most part, you can't get, with some exceptions, the Supreme Court, at least not the Supreme Court of Nevada, to disturb the facts on appeal. This leaves too much of a door open, even for me, somebody who's in the system more, or has been in the system more than the average person, by probably a lot. Even I still have to agree with those groups, and I don't think that I will ever change my mind until the legislature, at least of Nevada, hopefully the legislatures of all 50 states, clamp down on these gigantic gray areas. It's not enough to make the statutes gender neutral, because a judge's bias is going to bleed through where the judge has discretion. My sad experience is that this idea of just trusting judges to just do the right thing is so misplaced. It's as if the legislature lives in this little fantasy land, that all of these judges are going to really try their hardest to do the right thing. To their credit, I think a lot of them do, and they mess up anyway, because they have preconceived notions, they have erroneous opinions. I talk a little bit about it in my video. End of filings is not end of abuse. I think that's where a lot of my family or our family judges make mistakes. They think that the person filing papers must be the abuser, and that the person who's not filing anything must not. A humongous erroneous way of thinking, I guess, a wrong-headed idea that leads to abuses of discretion and erroneous decisions all over the place in the state of Nevada, probably all over the country. Other things that I've seen them do is they feel bad for the person who's got an attorney. Imagine that. The person who has no lawyer, they don't feel as bad for it, because you're not spending any money. They feel bad for your ex who has an attorney, who can afford an attorney, and has to pay money to litigate, whereas you can come in for free. They don't understand that some people just don't have the money. It's not that they're choosing. I can't imagine anyone who would choose, who had the money to hire an attorney and would choose to go in alone. These are such common mistakes. It's not like it's just one judge that's doing this. That there's just no way that even I could possibly trust the system in the future. My current marriage is great, but if this ever fell apart and we divorced, I wouldn't get married again. And it has nothing to do with being jaded about my partners. It has everything to do with being jaded with the system. So again, I do not think that, at least in the context of the family law system, I do not think that these organizations are overreacting, and I do not think that they are going to change their minds anytime soon. And maybe it's possible that it just won't ever happen. It may be that this is something that people in a democracy just will never fully understand until it gets so bad that it's just impossible to ignore. It's going to be an issue, at least in this country. So I think this, again, what I think the solution is to first purge the system of incompetent judges, and to second, go through the entire statutory scheme in divorce and child custody, find out where the judges have wide latitude and cut down on that latitude, constrain those judges, chain them down by the statutes. Use the plain language rule. I'm partially talking to legislatures. Don't use ambiguous language. Don't give them reasonable. They use this word reasonable. Who knows what the heck reasonable is? That can be interpreted anyway. Best interest of the child. They have tried to define it, but they could do a little bit better to define what that means. And I think unless they shackle those judges down as much as possible and bind them by the language of the statute, there's just not going to be any trust in the system. In fact, recently I saw a new statute. I guess you could call it new. I didn't notice it until just now, even though it was enacted in 2013. Relatively new for the legal system. I just saw a statute that authorizes the judges in Nevada, anytime they're making a determination on custody, legal or physical, or visitation, to award attorney fees. There's no limitations on this. If anyone here has watched my video, Defend Against Attorney Fees, you'll see that I mentioned that at least in Nevada, in the old days, because you can't do this anymore apparently, you could defend against attorney fee awards by claiming that the judge failed to show that you filed something without a reasonable basis, or that you are harassing your opponent, which requires evidentiary support. Now, there's a new statute that just says the family judges can just award fees whenever they feel like it. You don't even have to be the losing party. I'm sorry, you don't even have to be the winning party and you can get fees now. There's absolute this movement. The movement, at least in Nevada, is going in the wrong direction. They're widening discretion. They're giving the judges more leeway. They call it carte blanche. They're giving the judges a blank check to do virtually. It's really upsetting, and I have to say that these groups have a legitimate grievance with the system, and that's coming from somebody who you'd think would be really comfortable and feel totally safe navigating it. I hope that this video really sends a message. It is a problem, and it's not going to go away until the system is purged of incompetent judges, and until the child custody and divorce statutes are carefully re-examined and tightened up, so that there is as little leeway as possible for the family judges. I think that the people who write the laws, who are not knee-deep in the system on the front lines, have a completely different idea as to what's going on in these child custody cases and family cases than the rest of us do. I think there's a big disconnect there. I'm not sure that it will ever go away, because typically the people that are writing the laws are they're on a whole nother level of society, and they really, I don't imagine that a lot of them have been where we have been and can understand what we have gone through and what we are going through. And for that reason, I really don't have a lot of faith in the system, as far as the system being able to repair itself from the top down. I think this is going to be something that happens when the voters figure it out and start firing people. So until that happens, I have to say I agree with both of the groups. And one little thing I will mention is that the the alimony and the child support issue and the child custody issue is where both the M.R.A and the M.G.T.O.W groups seem to intersect on. What sets the M.G.T.O.W groups apart with not even wanting to get in relationships appears to be the gender bias that they perceive in the domestic violence accusation area, which can lead to orders of protection, restraining orders, and stuff like that. So I thought I would add a little bit of clarification there. I'm sure both of these groups have a whole bunch of other I don't know if they call it platforms, planks, whatever, opinions that are outside the scope of the channel, and I'm not going to really cover them because that's just not what I look into on this channel. So if anyone has any comments, feel free to post them in the comments below, and with that, I will see you guys next time.